Hey there, everybody. It's Jesse Weber, and thanks for joining us. We're breaking into your programming because any minute we plan to go live in a hearing for Lori Vallow Daybell and her husband, Chad. This is the couple who are facing evidence tampering related charges in connection with the grisly discovery of Lori's now deceased children. The hearing today is to determine whether or not cameras will be allowed in the courtroom for the upcoming preliminary hearings for this duo. Now, the special prosecutor in this case, Rob Wood, had moved to ban video access, saying that given the high-profile nature of this case, allowing courtroom feed would ultimately taint a potential jury pool. Now, local, regional, and national media outlets, as well as the defense attorneys in this case, have objected to this motion, saying that the public has a right to access this case. It's a public information access, especially when we're in a COVID-19 world, and the ability of people to actually be in that courtroom is not really a realistic option. So we plan to jump live, and we will, but in the meantime, let's preview what we can expect. The last time Lori Vallow Daybell was in court was regards to these misdemeanor cases, these misdemeanor charges. So she's facing felony charges in one jurisdiction and misdemeanor charges in another jurisdiction. And there was a question whether or not her bail should be reduced for the misdemeanor charges. Listen to the back and forth between her attorney and the prosecutor. You're going to get a sense of this once the hearing goes live, these different arguments and the style of both attorneys. Take a look.
The only thing I would add, in addition to the things that have been argued in the previous two bond hearings, is my client has been a model inmate. These charges are not of a violent nature. There is no previous criminal record regarding my client in any other jurisdiction that we're aware of. Her access to funds is extremely limited. I think the court has issued an order previously outlining that if my client were bailed out or bonded out, that there were certain restrictions in place that we're fine with keeping those restrictions. We think ultimately that the $1 million bond isn't reflective of the current charges, that we'd ask that the court reduce it to $100,000.
When the defendant obstructed the investigation into the safety and welfare of JJ Vallow, she was hiding the location of her dead child. When she attempted to get Melanie Gibb to lie to the police on her behalf, she was attempting to get Miss Gibb to lie about the location of her dead child. And when she refused to comply with a lawful order to produce her children, she did so in an effort to conceal the deaths of her minor children, all while telling family and friends that they were fine. And so, Your Honor, those aggravating factors that bear on the likelihood of conviction are troubling, they're strong, and quite frankly, they also bear on the defendant's character, which the court is allowed to consider in a bail reduction hearing. Acknowledging these charges are misdemeanors, if the court is so inclined to lower bail, we'd ask that it be no lower than $250,000, and we would ask that all the current restrictions on bail and her release remain in place.
Now, the bail was ultimately lowered, but of course, we can't forget that she's currently in jail on a $1 million bond in Fremont County, where she faces the most serious charges. Let me bring in my panel to talk about what we can expect. I'm joined by Law&Crime legal analyst Terry Austin, criminal defense attorney Eklund Mercy, and the person who's been following this case from the very beginning, our executive trial producer, Kathy Russin. Great to have everybody here. Kathy, I'd like to start with you. So the defense attorneys have objected to Prosecutor Rob Wood in this case, and they have said, you know, the public has a right to access here, but they seem to suggest we have a right to respond to what's been happening in the public, that the cat has been let out of the bag, that the public has already gotten a sense of what this case is about. Now, I just got word, Kathy, stand by. We can go live into this hearing. So we're going to get all these questions answered. Let's go live. The question, of course, will cameras be allowed in the courtroom for the preliminary hearings? Let's go live.
Go over this issue now.
Mr. Wood, you're coming through clearly, but it's pretty quiet. Do you mind speaking a little bit louder?
You bet. I'll talk louder. I'd just really quickly like to clarify one thing. In counsel's briefs, it stated that the state has gone on TV in this case I just want to clarify that the state has never, or I have never gone on TV to present analysis of the facts of this case. I believe that some coverage of Zoom has been lifted and used, but I have never done that. I have never given an interview in this case, and the state has taken steps to ensure that law enforcement follows that same protocol. Rule 45 makes it clear that the decision on whether or not to allow video cameras is subject solely to the discretion of the presiding judge, and that the court may limit audio or visual coverage of any public hearing when the interests of the administration of justice requires. In terms of timeliness of this, I know that was brought up. Rule 45 allows the court to consider this issue and revoke permission to allow audio or visual at any time. And again, for clarity, the state is making a motion solely for the use of video cameras to not be used. We're not asking for a closed hearing. We're not asking for a sealed hearing. And at this time, we're only asking for this in terms of the preliminary hearings that will happen in the next couple of weeks. I'd note that both counsel, Mr. Means and Mr. Pryor, correctly did note in response to my mentioning venue that venue is an issue to take up at a later time. The state's sole reason in mentioning venue is that a change of venue analysis revolves around the possibility of jury bias, which is the reason why the state has brought this motion as well. As stated in the brief I submitted, the state's primary concern in terms of broadcasting video of this hearing or these preliminary hearings on television or the internet, live streaming it on the internet, is that the ease of access to a pretrial evidentiary hearing in a case with such notoriety will cause damage to a jury pool in terms of bias. The state does not believe this is simply a hypothetical issue. The level of public interest in this case is so high that the probability that potential jurors, whatever the venue may end up being, will not be exposed to a production of evidence is unlikely. The state strongly maintains that said exposure to the production of evidence in a courtroom setting not only will create bias in potential jurors, but also the fact that it creates the appearance and possibility of bias is sufficient for this court to consider not allowing video cameras in the courtroom. Now, in reading the media's objection, and I want to state for the record, I have a lot of respect for the media, for these news agencies, and I understand they do a lot of good. And so the state has no problem with the media. However, in reading their objection, the state has done some further research on this subject. And I'd first point out that according to the United States Supreme Court, there is no such thing as a constitutional right to televise inside a courthouse. That can be found in Gannett County versus DePascal, which is found at 443 U.S. at 381. And that can be found in Estes versus Texas, which is at 381 U.S. 532. And in response to the media's objection, the state would encourage the court to review Estes versus Texas, as it outlines the possible dangers of broadcasting pretrial hearings and the bias it can cause potential jurors. In regards to even the possibility of creating bias in a future jury, the state would note the following from Offutt versus United States 348 U.S. 11, when the Supreme Court stated, "A fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of the cases, but our system of law has always endeavored to prevent even the probability of unfairness. To perform its high function in the best way, justice must satisfy the appearance of justice." The state is mindful of the effects of COVID-19 and the difficulties it raises for all the parties involved. We understand the difficulties it raises for the media in terms of being personally present. However, the public's right to know what happens in this hearing, which is important, and the state absolutely believes in that right, but it is satisfied by the public and the media's access to court transcripts and audio of the preliminary hearing. It's not necessary to live stream and broadcast video of the preliminary hearing when doing so creates such a high probability of affecting future jurors. And so with that, Your Honor, the state would again renew its request that the court not allow video cameras in the courtroom for these preliminary hearings.
Thank you, Mr. Wood. I appreciate your argument. I'll next hear from Mr. Pryor.
Judge, in this particular case, I'd like to clarify a few things. I appreciate Mr. Wood making note regarding the public statements and that he has not made any public statements. It seems that Mr. Wood's argument seems to be centered around avoiding any sort of public display of any of these proceedings, and I appreciate that. My concern is that in all of the historical documents going back to our founding fathers, the very basis of a trial was that it was going to be a public trial, and that the public had a right to see and view the proceedings. And quite honestly, that's still the case today, maybe for different reasons, but it's still the case today. I don't believe we need any more media coverage than we've already had. We have had a tremendous amount of media coverage. I've pointed out that even at the Madison County Courthouse, they've wrapped blue ribbons around the poles around the courthouse and at the prosecutor's office. And that had been there up until late last week. I did notice when I went by there today that somebody took the blue ribbons around. So the argument that there hasn't been already a significant amount of press and a significant amount of media coverage in this isn't going to make any difference. I pointed out in my response, Judge, and it wasn't in the way of an objection to Mr. Wood. It was more in the way of offering the fact that the court, I think, took a deliberate and very thoughtful approach to how they decided to allow the public having their right to view these proceedings. And I think the court took a lot of time and weighed this very carefully when you first made your decision. And I think that decision shows the amount of forethought that this court had. Obviously, the court wasn't aware that the pandemic was going to escalate, and the court making its ruling obviously had the forethought to recognize that maybe that would have happened. And there are two options here. Option number one is to open the courthouse and allow everybody to be present in the courthouse, and my client's family and any other interested parties to be able to offer their support and to be present for the proceedings. Now, obviously, because of the medical pandemic, that's not possible. And we can't in any circumstance risk that sort of situation. So the only other option that I see, Judge, is to do exactly what this court ruled in its initial decision. And I think that initial decision was correct. I think it was done with a lot of thought. And I think at the present time, it's the appropriate decision. And Judge, I would just ask that you allow your initial decision to stand. And I think that's the way we need to proceed in this matter. Thank you, Judge.
Thank you, Mr. Pryor. Mr. Means, I'll hear from you next.
Yeah, just real brief, Your Honor. I think the court's been briefed, obviously, by Mr. Pryor, myself, and the state, and Mr. Wright in this case. I don't think we need to repeat it. I think the ultimate summary is, in this case specifically, I think you could sum it up with the statement of the cat's out of the bag. I think the attention that this case has received as far as media attention, analysis of certain evidence that has been placed in the attention of the media has already occurred. I think the argument to not allow this to be televised is more accurately applied to how can it affect at this point in time with a reservation to challenge venue, how can it affect the citizens of Fremont County? I don't think there's any difference on whether it's televised or not, or how it's going to affect the citizens of Fremont County. Again, I think the point has been made with the media attention to this case that the court has already considered what has happened, what is seen, what has been filed in this court in issuing its initial order. I don't think there's really grounds to reconsider that order or amend that order as is. So our position would be, Your Honor, just to deny this motion and continue forward as the court already issued its order quite a few weeks ago.
Thank you, Mr. Means. Mr. Wright, I've received your motion and your objection that was filed in case number CR 2220-838. I note that it was not filed in the other case of 755 State of Idaho versus Chad Daybell. I've read thoroughly your brief as well as your argument. Is it your intention to make argument here today, Mr. Wright?
Yes, if that's permitted, Your Honor.
Generally speaking, I would allow it. However, I note that there was your filing was very recent, and I understand that everything's been put on fast forward just because the preliminary hearings are fastly approaching. Mr. Wood, what is your position with allowing Mr. Wright to argue beyond what he has filed as far as his objection?
Your Honor, the state doesn't have a problem with it. We may want to respond, but we don't have a problem with it.
Mr. Pryor?
Judge, quite honestly, I wasn't provided a copy of Mr. Wright's pleadings in my particular case. Mr. Wood was kind enough to provide me with a copy, and I had an opportunity to review that. I don't want to delay the ruling by this court. So my position is simply, Judge, that Mr. Wright can stand on his pleadings as they've been presented. In both cases, that's fine, but I would prefer that he not make any comment and that we just stand on the documents as they've been provided to the court, and the court make its decision based on his pleadings. For giving him an opportunity to speak, I think would create a situation where I haven't had an ample opportunity to prepare. And I think, quite honestly, that wouldn't be fair to Mr. Daybell. So at this point, it appears that Mr. Wright and I are on the same page in terms of the remedy that we're seeking in our particular case. And I don't want to speak for Mr. Wright, but I think the only opportunity is for the court to live stream these proceedings. And I think that was the gist of what Mr. Wright had presented. So at this point, Judge, my preference is that Mr. Wright be advised that we're going to just review his documents, and then the court can make a thoughtful decision.
Mr. Means, do you wish to be heard on the issue?
Just real briefly, Your Honor, I'm in agreement with Mr. Pryor without regurgitating all the arguments there. My concern would be if he's not allowed to voice argument today, that this matter will be pushed and might interfere with the scheduling of the preliminary hearings. So at this point, no objection.
All right. Mr. Wright, I'm going to allow you to do this. I'm going to allow you just a few minutes here to highlight some of your bullet points. I do feel that giving you a lot of time to argue is prejudicing Mr. Daybell because he was not provided with information regarding to your argument. If you want to make a few bullet points, I'll allow you to do so. Otherwise, I'm going to deny your ability to make argument today for the reasons I've just outlined. Do you wish to make a few points?
Of course, Your Honor, and I appreciate the comments of counsel and the court's consideration. I'll be very brief. The first point may be just to help explain the clerical issue here. I became aware of the issue specifically on Thursday, and I was only aware of the motion filed in Ms. Vallow's case. Hence, I drafted and submitted my brief the next day in relation to that. However, my arguments I would submit are applicable to both, Your Honor, and would ask for the same result. I won't repeat what is in the brief. The court's well aware of that. To the extent that the state has cited new cases, however, if the court believes those are worthwhile and have merit in terms of changing its order, I would respectfully request the opportunity to respond to that, given that they were provided only at this time. Your Honor, I'll just briefly summarize it by saying that we believe that the video feed is really the very appropriate solution, balancing all the factors in this case. It's the least intrusive method. It is a way to provide accurate information. And as I cited in the brief, publicity itself is not a bad thing. In fact, it's a good thing. The concern is bias arising from inaccurate information. And there is no better way to make sure that accurate information is provided than through a video feed. The state, who I will say that the media reciprocates and does not doubt the respect that the state has indicated exists here for the media, that is reciprocated. We just believe the approach sought is incorrect here. And the indication is, well, that information can be obtained after the fact through audio and transcripts. That accomplishes nothing other than interfering with the media's ability to try to provide appropriate coverage in this case, coverage that will occur. And so we believe that hindering it by referring after the fact to that information accomplishes nothing that will address the state's concerns. Let's see if there's any other comment. I want to be brief as the court has requested. See if I have any other comment. I guess, Your Honor, I would just say this. We do understand that this is under Rule 45. We understand the context of the Supreme Court cases cited by the media as well as by the state. We all know that none of those dealt with their circumstances as they are now. The idea of the fact that this virus has created the conditions that it has is unfortunate, but only lends itself to the idea that video here is the best way to address this situation and to balance all of the factors that we believe are necessary. And so, Your Honor, I realize this is brought under 45, Rule 45, but it does by definition include serious constitutional issues, because in this case, shutting off the video feed is effectively the same as closing the courtroom, even if transcripts may be available later. I thank you, Judge.
Thank you, Mr. Wright. Mr. Wood, this is your motion. I'll give you the last word if you'd like it.
Just briefly, Your Honor, I'd point to the fact that the United States Supreme Court right now, even with COVID, they are not live streaming. They don't allow video cameras. So there's at the highest level of precedence for this information to be distributed by other means. And that's all I'd state, Your Honor. And we renew our request. Thank you.
Thank you. Mr. Pryor, I designated that if there was something that you wanted to respond to, because Mr. Wright was given a chance to speak, I'd allow you to do so. Anything else you'd like to say?
Just simply, Judge, I agree with Mr. Wright in the sense that a defendant has the right to a fair public trial. And I agree with Mr. Wright that under normal circumstances, Judge, my preference would be that this hearing, this preliminary hearing, would be done with the courtroom opened, and those that felt the need to participate and show up would have a chance to view that. And unfortunately, Mr. Wright pointed out that that isn't an opportunity for us. So I think the only alternative at this point is to stream this. And as far as what Mr. Wright said about giving the opportunity for the public to view something, a videotape after the effect or a transcript after the effect doesn't accomplish the same thing. Quite honestly, the public has a right to see this. I would prefer that it was done in a courtroom and not on a live stream, but the public has a right. And we as much as I want to be aware of Mr. Daybell getting a fair opportunity for a fair public trial, I believe that your initial decision was well thought of and well based and should probably stand at this time. Thank you, Judge.
Thank you, Mr. Pryor. Mr. Means, anything else to add?
No, Your Honor, I think the only thing I'd add is in the court's analysis, I think given the media coverage of this case already, the public's right outweighs the potential argument of fairness for the defendants in this case.
Thank you. All right, the court has listened carefully to the arguments that have been made by the state counsel for both defendants as well as counsel for the media. The court has done its own research in preparation for today's hearing. The court is appreciative of the fact that Mr. Wood, on behalf of the state, has filed this motion. The court feels that it's genuine, and ultimately Mr. Wood, as the state or the prosecuting attorney, does have a right to seek justice. And I feel, based upon the motion that has been filed, that ultimately Mr. Wood is doing all that he can to preserve justice and preserve the right to a fair trial. The court has listened carefully, and I'm prepared to rule from the bench on this matter. I will issue a written decision later, but I am going to issue a oral ruling right now from the bench and then follow that up. I'm aware of the defendant's rights to a fair trial in Idaho, or Article 1 of the Idaho Constitution, and the 6th Amendment to the United States Constitution. The court also recognizes the First Amendment rights of the press and public access to the courts. This is a high-profile case, and people have a lot of feelings about it. It is a priority for the court to be transparent in its process so that the public can be assured of the fairness of the judicial system. The public has a right to access court proceedings and should have the ability to scrutinize the court proceedings. even scrutinize what each of us do in our own roles here in the judicial process. The court has looked at various ways to balance the constitutional rights of the defendants as well as the public's right to know. COVID-19, the coronavirus, is an unprecedented global pandemic that has impacted the government and subsequently impacted the judicial system here in the United States and here in...
All right, I hate to do this, but we have to hit a break. It sounds like the judge is going to allow cameras, though. That's based upon my opinion about what I'm hearing. We do have to hit this break, but up next, Law&Crime Now, we're going to break down exactly what the judge has held here. Big implications. Stay tuned. We'll be right back. And welcome to Law&Crime Now, everybody. I'm Jesse Weber. Thanks for joining us. We are live right now in a hearing in the Vallow Daybell and Chad Daybell case, the couple who have been charged with evidence tampering-related counts in connection with the discovery of Lori's children. Let's go live right now. What is being determined, and what I just heard the judge say is that he will allow broadcasting of the couple's preliminary hearings that are upcoming. Let's go live.
Both cases, State v. Chad Daybell and State v. Lori Noreen Vallow Daybell. I'm also noting for the record that subsequent order that was issued by the Supreme Court just recently, it was issued on July 24th, only a few days ago. Obviously, that order would play a role in how we proceed as well. It shouldn't affect the preliminary hearing to a great extent, but in the event that it does, we'll need to follow that order as well. On behalf of the media and access. Any other questions, Mr. Wright?
No, thank you, sir. I appreciate the clarification.
And just so it's clear, I'm denying the motion to reconsider in both cases, and my ruling will stand in both cases. Be in recess right now. Thank you all for appearing.
Thank you.
Thank you, Your Honor.
Well, you just heard it. That was Judge Edens officially denying the prosecution the state's motion for reconsideration. Ultimately, the state was trying to say that cameras should not be allowed in the upcoming preliminary hearings because that might taint a potential jury pool. And as the judge said, he listened to both arguments but weighed the interest pretty heavily and said in light of everything that's going on, especially with COVID-19, it is particularly important to have this transparency in the courtroom. This is a high-profile case, so it appears that one media outlet will be allowed to broadcast and one media outlet will be allowed to photograph. Let's bring in my panel for right now. Again, joining me is criminal defense attorney Eklund Mercy, Law&Crime legal analyst Terry Austin, and the person who's been following this case from the very beginning, executive trial producer Kathy Russin. Great to have everybody here. Kathy, I'd like to start with you. Your thoughts on this? This is a huge win for everybody in the media, including Law&Crime, the fact that we will be allowed to see what happens in these preliminary hearings, particularly because I feel there are so many details we do not know yet that the authorities have against the Daybells.
Right. I have to say I'm not shocked. I don't think the judge had any, he had to allow this because of the pandemic. He has to allow the ability for the public and media to be inside that courtroom. And because of COVID-19, he can't do that right now. So I did expect that he was going to allow this to go forward, and I'm glad that he did. And you're right. The preliminary hearing, I expect we will learn details that are not out there in court documents yet that we have seen.
Terry, let me turn to you. You've been following this case from the beginning as well. This is interesting because I know that the state had the burden here, an uphill battle, but they were presenting a pretty interesting argument that the idea is you can't get somebody in Fremont County if you broadcast these preliminary hearings who's not going to know about this and that they're going to be following this and this is ultimately going to be unfair. And that's a big problem here. What did you make of that argument? Because we are living in a very different situation with COVID-19. There wouldn't be a lot of people allowed in the courtroom. And it seemed that argument was strong, but clearly not strong enough.
Exactly. The judge made the right decision here. There's no question that under the Sixth Amendment of the Constitution, and you heard the judge mention the First Amendment under the Idaho Constitution, not to mention First Amendment right for the press, we absolutely need to have the trial live streamed and making sure we have photographs, and it's the right of the defendant and it's the right of the public. So I think when the prosecution made this motion, it was a losing motion. The fact that the defendants themselves, this protects the defendants, and they did not object to having this videotape. So I think the prosecution was grasping at straws, and I think the judge made a good decision in making sure that his original decision stands and that these hearings can be televised.
Yeah, I do want to get into the defense's argument in a minute, but before that, let's just turn to what you might have missed if you're just tuning in. So this was a portion of Rob Wood, the special prosecutor in this case, talking about why cameras should be banned. Take a look.
Absolutely abide by any pretrial release conditions, any sort of monitoring that the court requires, but there is simply no basis for a bond this high, and it must be reduced given the charges that she's facing. For those reasons, Your Honor, we would ask that you grant the defendant's request to reduce bond.
This case didn't start as a criminal case, Your Honor. It started as a report of 2 missing children who were still missing. November 25th, Rexburg police late in the day get notice that this young child is missing. Within 24 hours, they respond. When they respond, they're given verifiably false information by the defendant. And so the next day they obtain warrants and to search the residence for the child. And at that point, the defendant is gone. Now they say it's a planned move. Maybe they did plan to move to Hawaii. However, they clearly left very quickly as soon as they were contacted by law enforcement. The vast majority of their belongings were still in that apartment. And so the investigation continued. A Child Protection Act was filed. And an order was given for Lori to produce the children, for the defendant to produce the children, which she did not do. I'll address this issue that she informed law enforcement that she would turn herself in. It's kind of hard to trust someone to turn themselves in on a warrant when a simple welfare check caused that person to leave.
Okay, so that wasn't exactly the right clip, so we're going to turn to that in a second. We're going to turn actually to Rob Wood speaking during today's hearing. But before we get into that, Eklund, I'd like to turn to you. Let's talk about the defense for a second. Terry was saying that she was a little surprised that here the defense was saying, yeah, we're objecting to the state's motion here. We want cameras in that courtroom. Why do you think they wanted that? Because if you read their briefs, I got the sense that they're saying, listen, people have already made up their minds. They got people with signs out there. People have already had strong opinions about Lori Vallow and her husband. Maybe it's our time to respond, and we want people to have a front row seat to what we're going to say in the courtroom. You think that's what's going on here?
I honestly think they're playing both sides by not being real staunch in objecting like the state. They're just like, hey, we're just going to play in the middle, because usually it's rare that you see the state not wanting it to be publicized. Usually they would love to present a good show. So that's rare. So for them to make the argument, for them to not be able to, get over the public scrutiny, and you already showing your hand, and trial and the prelims haven't even started yet. As a defense attorney, you're just going to bide your time. And what you do is if something were to happen potentially because of the broadcast, because of it being public, then as a defense attorney, we can say, hey, man, the prosecutor even warned you guys that this would happen. Now look at what happened. So right. I think that they're playing it safe, and I think that they did a good job.
Well, let's actually turn to Rob Wood again, the prosecutor, special prosecutor in this hearing. This is him actually arguing for no cameras in the courtroom.
And that the court may limit audio or visual coverage of any public hearing when the interests of the administration of justice requires. In terms of timeliness of this, I know that was brought up. Rule 45 allows the court to consider this issue and revoke permission to allow audio or visual at any time. And again, for clarity, the state is making a motion solely for the use of video cameras to not be used. We're not asking for a closed hearing. We're not asking for a sealed hearing. And At this time, we're only asking for this in terms of the preliminary hearings that will happen in the next couple of weeks. In the brief I submitted, the state's primary concern in terms of broadcasting video of this hearing or these preliminary hearings on television or the internet, live streaming it on the internet, is that the ease of access to a pretrial evidentiary hearing in a case with such notoriety will cause damage to a jury pool in terms of bias. The state does not believe this is simply a hypothetical issue. The level of public interest in this case is so high that the probability that potential jurors, whatever the venue may end up being, will not be exposed to a production of evidence is unlikely. The state strongly maintains that said exposure to the production of evidence in a courtroom setting not only will create bias in potential jurors, but also the fact that it creates the appearance and possibility of bias is sufficient for this court to consider not allowing video cameras in the courtroom. Now, in reading the media's objection, and I want to state for the record, I have a lot of respect for the media, for these news agencies, and I understand they do a lot of good, and so the state has no problem with the media. However, in reading their objection, the state has done some further research on this subject, and I'd first point out that according to the United States Supreme Court, there is no such thing as a constitutional right to televise inside a courthouse. That can be found in Gannett County versus DePascal, which is found at 443 U.S. at 381, and that can be found in Estes versus Texas, which is at 381 U.S. 532. And in response to the media's objection, the state would encourage the court to review Estes versus Texas, as it outlines the possible dangers of broadcasting pretrial hearings and the bias it can cause potential jurors. In regards to even the possibility of creating bias in a future jury, the state would note the following from Offutt versus United States 348 U.S. 11, when the Supreme Court stated, "A fair trial in a fair tribunal is a basic requirement of due process."
Kathy, when we're listening to this, we can't forget that Stephen Wright is the attorney who was hired by media outlets. I'm talking about local, regional, national media outlets. Why has there been so much attention to this case? Why is there such a need to know what happens in that courtroom? Why have people taken a grasp of this case, whether it's if you're in Fremont County or across the nation? I mean, you've covered a ton of trials. Why is this one have so much focus?
Across the country, and I even say it's touched different parts of the world because our viewers come from all over the place and they are obsessed with this case. It started out because 2 children were missing, and we always care about that. But then you have to surround that with the seemingly crazy thoughts and beliefs of Chad and Lori, and that people turn into zombies. And then all of a sudden, all these people around them are dying, current spouses, their children, a brother, former spouses. There's so much intrigue around this case and these defendants. People want to know why and exactly what happened.
And let me ask you this, Kathy. We're listening to this. We get the attention. The idea, I mean, you were there. You were in this community. Do you feel that people have already made up their minds, or do you think that it will be possible to get an impartial jury, or will they have to go somewhere else? Because you got a sense of what people's feelings are about this case there. So this idea that the cat's let out of the bag, which is something Mark Means said, is that true?
Yes, and I understand what the defense was saying today about the blue ribbons everywhere and signs everywhere. They are everywhere there. Everywhere. When you drive there, it's 2 towns. Rexburg is where Lori was living, and Chad was living in Salem, which is just the little town right next to Rexburg. It's everywhere. Look, I think it will be hard to seat a fair jury. I think that makes no difference whether we see upcoming hearings or not. The cat is out of the bag. It's already everywhere. Saying that, there are still some people that just don't care about this stuff. And I have to say this because we always laugh about this kind of. My husband doesn't care. He doesn't follow these kinds of cases. He doesn't get into all that. So there are people out there. And then there are people that have heard it all that can be fair. But as far as it's already done now, the media has already been so crazy that it really doesn't matter if we show hearings.
But here's the thing, your husband's not in Fremont County, he's not in Madison County, and that's the issue here. Do we get a jury from these locations? Does it have to be moved out of state? Does it go to a different territory? That's the question. I have so much to talk about with the Daybell case. I know we have to hit a quick break, but when we come back, we're going to dissect what will happen next. Stay tuned, we'll be back. And welcome back, everybody. We're still breaking down a monumental hearing in the Lori Vallow Daybell and Chad Daybell case. The judge has officially said that he will allow cameras in the preliminary hearings, the upcoming preliminary hearings for this couple. That's a huge win for public transparency, media outlets, and for the public to understand what was going on here. Now, let's listen a little bit to John Pryor, who's representing Chad Daybell, and you'll hear, which is, again, very interesting that the defense in this case wanted cameras in the courtroom, but you'll hear yourself what their arguments were. Take a listen.
The public had a right to see and view the proceedings. And quite honestly, that's still the case today, maybe for different reasons, but it's still the case today. I don't believe we need any more media coverage than we've already had. We've had a tremendous amount of media coverage. I've pointed out that even at the Madison County Courthouse, they've wrapped blue ribbons around the poles around the courthouse and at the prosecutor's office. And that had been there up until late last week. I did notice when I went by there today that somebody took the blue ribbons around. So the argument that there hasn't been already a significant amount of press and a significant amount of media coverage in this isn't going to make any difference. I pointed out in my response, Judge, and it wasn't in the way of an objection to Mr. Wood. It was more in the way of offering the fact that the court, I think, took a deliberate and very thoughtful approach to how they decided to allow the public having their right to view these proceedings. And I think the court took a lot of time and weighed this very carefully when you first made your decision. And I think that decision shows the amount of forethought that this court had. Obviously, the court wasn't aware that the pandemic was going to escalate, and the court making its ruling obviously had the forethought to recognize that maybe that would have happened. Option number one is to open the courthouse and allow everybody to be present in the courthouse, and my client's family and any other interested parties to be able to offer their support and to be present for the proceedings. Now, obviously, because of the medical pandemic, that's not possible. And we can't in any circumstance risk that sort of situation. So the only other option that I see, Judge, is to do exactly what this court ruled in its initial decision. And I think that initial decision was correct. I think it was done with a lot of thought. And I think at the present time, it's the appropriate decision. And Judge, I would just ask that you allow your initial decision to stand. And I think that's the way we need to proceed in this matter.
Terry, let me turn to you, because if you take the state's word for it that they're afraid of tainting a potential jury pool by pretrial publicity, a pretrial live stream of these preliminary hearings, okay, that makes sense. But let's just take a different avenue here. Is there something that perhaps the prosecution didn't want everyone to see in the preliminary hearing? And I know that they said, look, we'll have still photography, we'll have transcripts, you just don't need a live stream. But is there something that perhaps they didn't want to see? Because there's so much of this case, so many of the details that we don't know yet. So if you take that position, in your experience, is one of the reasons a prosecutor maybe doesn't want a live stream yet is a live stream of these preliminary hearings for a different reason other than the jury?
Jesse, it's funny you should ask that, because I was trying to think in this case why the prosecution would not want this to be videotaped. And it has to be that it's trying to hold back. And we know for a fact that the murder charges have not been brought yet. So maybe I'm thinking that they don't want any information to get out until they are ready to bring those charges. So interestingly enough, they are objecting to having video access. And it's something that doesn't usually happen as far as the prosecution is concerned. They do generally want to have this showcase before the public. So there must be something in their back pocket to want this information to be tightly held until such time they're going to be able to use it. I am hoping to bring the charges for murder against both Lori and Chad.
I want to talk about that. Eklund, After a preliminary hearing like this, now that we're all going to get a chance to see it, we're going to get to see what the state has, we're going to hear the defense's arguments. Does that become a time when either A, maybe the prosecution wanted to see what the defense was going to come up with or how their strategy is going to be, and then say, wow, they're really weak, let's hit the murder charges? Or does it become a case where maybe the prosecution says, maybe we're not so strong, and maybe they're open to trying to work out, or maybe the defense is open to working out some kind of deal? Do we see a change in the status of a case after preliminary hearings?
Well, in the prelim, it's up to the state to provide probable cause to show that there's probable cause for the arrest. Now, with regards to this case, I can see why the prosecutor wouldn't want it recorded, because the level of craziness in the media with this case is already insane. And, and it's just like, with a prelim, when it's not publicized, you have time to gauge the crazy. You have time to really understand how asinine this story is, how insane this story is. Does it make sense? You can gauge through the people in the galley. You can gauge through, the judge and the bailiffs. Like, how crazy is this case? But the fact that we have crazy sets of facts and it's been publicized worldwide, now you're stuck. The issue is that once a prelim is out here, you're stuck. And because the media has access to it, that's automatic impeachment. The defense attorney doesn't have to do it. The media will do it for you. So if you have, and sometimes the state is trying to grapple through what type of story they want, and through prelims, that's how they make the story. And if you have this crazy kind of prelim, you're stuck to this story. And based on the media, based on your coverage, based on Law&Crime's coverage, like the facts are insane already. So I think that's what the state is trying to do.
And look, from our perspective, we're thankful we'll be able to have cameras there. But also, I'm kind of thankful we have a show right now, considering, in Lori and Chad's belief system, we thought it was going to be an Armageddon last week and we weren't going to be able to broadcast anymore. That didn't happen. I want to get to that in a second. Before we do, it wasn't just the Rob Wood and it wasn't just the defense attorneys talking about cameras today. It was also Stephen Wright. He's a lawyer who represented the media outlets here. Listen to what he had to say.
We believe that the video feed is really the very appropriate solution, balancing all the factors in this case. It's the least intrusive method. It is a way to provide accurate information. And as I cited in the brief, publicity itself is not a bad thing. In fact, it's a good thing. The concern is bias arising from inaccurate information. And there is no better way to make sure that accurate information is provided than through a video feed. The state, who I would say that the media reciprocates and does not doubt the respect that the state has indicated exists here for the media, that is reciprocated. We just believe the approach sought is incorrect here. And the indication is, well, that information can be obtained after the fact through audio and transcripts. That accomplishes nothing other than interfering with the media's ability to try to provide appropriate coverage in this case, coverage that will occur.
All right. So, Kathy, no end of the world. We're okay. But Lori waived her right to appear during this hearing. Chad was there with his attorney. It was all done over Zoom. Did you find that interesting? I mean, you know this couple. You speak about this couple. You've been researching them. Did you find it interesting that Lori chose not to be there?
I even tweeted out when the hearing started that she waived her presence, and I tweeted out the word interesting, ... I don't know. Maybe I'm reading too much into it, but does she not want him to see her like that? Maybe she's looking a little haggard, or I don't know. I mean, we see defendants waive their presence.
Well, because he was visiting her every day before he got arrested. So it would be interesting to see both of them at the same time over this Zoom appearance. And I just find it interesting that that was a situation. I mean, because when you look at this couple and you think about what was going on here, from your perspective, and we could talk the law all we want, but what are you looking out for in their preliminary hearings, which I should note are on different days? But what are you looking out for, Kathy, from someone who's been following this? If you're a member of the public watching this, what are you looking out for from the preliminary hearings?
Okay, so first of all, actually, I just thought of something. Mark Means, Lori's attorney, is 4-hour drive from the jail. So I wonder if her appearance was waived because he didn't want to get there and appear together with her for this particular hearing. So that could be it. Well, I'm expecting to hear details. We already know some horrific details, but we don't know all the details about the remains, about what prosecutors' theory is, how things happened, when they happened, who did what. I do expect that we may not hear every little tidbit they have, but I do believe we're going to find out more than what's in public records right now. And that's what everybody wants to know. I mean, we kind of know where the prosecutor is going, and we kind of know he thinks that Alex Cox probably did the murders. Chad may have helped do the burying. Lori knew about it, but to hear more detail than that, I think is what we're looking forward to.
Yeah, you took the words right out of my mouth. Really, I want to know what the involvement or alleged involvement of Lori's brother was in all of this. And again, what we've talked about here on Law and Crime now is he really the one responsible for the deaths of these children? And the prosecutors cannot tie Chad and Lori. Maybe we'll get more answers during a preliminary hearing. And as you heard, we're going to have a front row seat to whatever happens. Kathy Russin, thank you so much. When we come back, Terry Eklund and I are going to discuss an update in the frost-proof triple murder case. Stay tuned.
I want you to think about this. This is Polk County, frost-proof, the very south end of the county. It's an extremely rural area. The county's 2,000 square miles. Population's almost 700,000, and all of it is from mid-Polk County north. So it's sparsely populated area that's made up of cow pastures, orange groves, beautiful lakes, and a very, very low crime rate in the frost-proof area, which is one of the best kept secrets and one of the safest places to live any place in the nation. But all of that came to a crashing halt on Lake Streety Road. When we found these people, our victims, massacred, literally massacred, we thought, my goodness, what could have happened there? Well, we know.
And that's the case that we talk about right now, the triple homicide out of Frostproof. It's a part of Polk County, Florida. And we talked about how 3 men were gunned down in cold blood. 3 individuals have been arrested and charged. Tony Wiggins, Tony TJ Wiggins Jr., he has been alleged to be the shooter in this case, while his brother and his girlfriend have ultimately been charged with being accessories after the fact. Now, I say this because right now, 4 new arrests have been made. Let's go through them. Tony Lee Wiggins Sr., Cheyenne Marie Eccleston, Nydia Yvette LeBoy, and Robert Keene. They were all apprehended and charged with environmental offenses, so nothing directly related to the shooting. But what we know is that they all lived in the same compound as the 3 defendants. Apparently, what we're dealing with here is that Tony Lee Wiggins Sr. and Robert Keene, these are actually the father and uncle of the Wiggins brothers, and also Cheyenne Eccleston was apparently Robert's girlfriend. So we're seeing this kind of connection here. Eklund, let me start with you. Interesting development. You know, these 4 people who were ultimately arrested, nothing to do with the shooting, but these environmental charges. Having said that, how could this factor into the case? Because these environmental charges, are they serious? Could they lead to some sort of bargaining chip? What do you think?
I think that they should be serious because the soliloquy that we saw the law enforcement make before, describing the nature of the charges kind of kind of, brought me to attention. Why would you talk about how rural it is and how beautiful the lakes are if you're not going to use something to that effect later on? So I have a problem with that. I have a problem when you have to explain and provide, random facts about your town when you have murders that happen in your town. So I'm really reluctant to say that I don't know what they're going to do with it, but it seems kind of fishy to me already.
Well, Terry, they've all been charged with nuisance injury to health counts. Now, it should say that Wiggins Sr. and Keene, they've also been hit with additional charges, but let's focus on these. What is that exactly? What are we saying was going on at the compound? And does that tell you anything or give you any insight into the larger story of who we're dealing with here?
It's interesting you should ask me that question, Jesse. Before we came on today, I looked up what that charge meant. And essentially, it's saying that their property is filthy, that there is waste on the property, and I'm assuming that it is from dogs or some other animals, that they don't properly dispose of their garbage. So essentially, what is going on here is the property has not been kept, and it's a nuisance to the neighborhood. So I find it quite interesting that they're being charged with this, and it's completely, as you stated, unrelated to the murder charges. And I guess when it rains, it pours, but they could use it as a bargaining chip, I suppose, but I did find it to be a very interesting development.
I know why.
Well, bargaining chip in the sense if you believe that these individuals have some information against the three defendants that might help a prosecution's case, or perhaps TJ would want to spare his father and uncle from these charges to somehow help the prosecution and cooperate, although he is not doing that at this point. We'll get into that in a second. Before we do, let's go back to Sheriff Grady Judd, who during this press conference laid out exactly who these three individuals are. We're talking about TJ Wiggins, Robert Wiggins, and Mary Whittemore.
This is the trigger man. This is the guy who directly did the damage. His name's Tony Wiggins. He's known as TJ. He's 26 years of age. This is Mary Whittemore. She's 27 years of age, and she is the girlfriend of Tony Wiggins. And this is Robert Wiggins. He's 21 years of age, and he's the brother, obviously, to TJ. But let me stop for a minute and give you a little history on TJ. TJ is someone who his criminal history should shock your conscience. It does mine. TJ started to be arrested when he was 12 years old. He is currently only 26 years old. TJ has 230 felony criminal charges in his arrest history. I didn't stutter. He had 230 charges in his arrest history, 15 convictions, and 2 times to state prison at only 26. There's a picture of Tony Wiggins. Here's the real Tony Wiggins. He's a thug. He's a criminal. He's pure evil in the flesh. He's wild and he's out of control. Mary has 0 criminal history, 0. Robert has 1 misdemeanor arrest, virtually no arrest. Tony, 230 felony charges. They all are from the Lake Wells and Frostproof area, as was our victim.
Okay, Eklund, let me start with you. It seems, from an outsider's perspective, this could be the worst candidate to defend. You have a guy who has such a storied criminal career history. Now he's charged with a triple homicide. His brother is apparently cooperating with authorities and says that TJ is the one who opened fire, and he and Mary were watching and ultimately tried to help out afterwards. But To defend someone like TJ Wiggins, what goes into that? How does that process ultimately go down? I mean, what do you do? How do you prepare for that?
Okay, so to defend Mr. Wiggins, you have to prosecute the state. So what that sheriff just stated was that Wiggins had 230 felony convictions. We have black men that are unarmed with no criminal history that are dying in the streets. This man has 230 felony convictions, and he's had felony charges, but he's had 15 convictions, spent 2 times, 2 bids in prison, and is still out free to kill again. They knew about him. So what I would do is say that he no longer is like, he's the weapon. He's not using a weapon. He's actually the weapon at every given point. At arrest number 150, they didn't do anything. They didn't help him. All I saw is, like, what I've read is that there's been countless nuisance complaints against these people. So although the other defendants didn't have an extensive criminal history, they were nasty. Like Terry said, they were kind of disgusting. So we can see that from the sheriff's soliloquy in the beginning about how beautiful his county is, that's kind of farce when you have somebody who is able to thrive and have friends who has 230 felony charges. So that's what I would do. I would put it on everybody else. What do you mean? You just said that you don't have any crime in your county, and the only person committing crimes is this one man, apparently.
Well, I'm curious to see if Mary Whittemore starts talking and she starts cooperating, given that she doesn't really have a criminal history. But with the arrest of all these different individuals who are living in the same area, who knows what will happen next. I will say, in a different kind of light, the funeral expenses for the 3 victims have been collected. So that is a somewhat positive light in this otherwise horrible story. We're going to take a break. When we come back, we'll focus on Johnny Depp's trial in the UK. Stay tuned. And welcome back, everybody. On to Johnny Depp's trial, his libel trial against the publisher of The Sun and its executive editor. And this is coming to a close, believe it or not. We're actually in the closing summations. And this is, again, about a 2018 article that labeled him a wife beater, an allegation that he adamantly denies. Now, the whole crux of this trial is about whether or not this is true. News Group newspapers cited 14 instances where Depp allegedly attacked his ex-wife, Amber Heard. And this trial, if you've been following it, if you've been following here on Law&Crime, it's gotten ugly. We have seen everything from accusations and stories of defecating on a bed, physical abuse, drug use, throwing a champagne bottle, crude and profane text messages. I'm telling you, it's gotten really ugly. And I want to get into what the verdict, what the decision is ultimately going to be. But before we get there, let's take a step back. Let's go to this infamous recording between Depp and Heard, where you can just hear them hashing it out.
We gotta change how we do things, and I want to trust you, and I feel like all the trust is gone. All the fucking trust is gone in the relationship because you keep splitting.
I'm not gonna be in a physical fucking altercation with you.
Then don't.
You fucking hit me last night. You fucking...
What about all the other times you split? Come on, you cannot act like that. It's about that. It's not.
Well, on a plane, I can't split.
No, and you hit back, so don't act like you don't fucking participate.
I pushed you.
I'm not going to get into the details of that fight. You and I both know that you split when there is no physical violence involved. And that you do it like at the very beginning of fights these days. And if you split and you go into a different room and you don't actually leave that house, it does nothing but perpetuate the fight. Really, when you split on me, how do you feel when I leave you?
When I split, when I go into the other room, you say.
And getting me a room, getting another room at a hotel is just the same thing.
When did I get another room at a hotel?
You text Steven or Nathan in Toronto to get you another room.
So, Terry, we've heard a lot. Actually, I should say we haven't heard anything directly in that case because there's no cameras allowed there, but we've been reading constantly about it. Terry, how do you predict the judge is going to ultimately rule here? My understanding is once the closings are done, the judge can deliver a decision they're predicting within a few months. I mean, my understanding is that for NGN to win, they have to show something called a balance of probabilities that Depp assaulted Heard. How do you anticipate this playing out?
I actually think that Johnny Depp is going to lose here. I mean, if this is a defamation case based on libel, there's so much information here that says there was some sort of altercation going on for quite some time, whether he butted her head or she threw pots and pans. There's just too much information that this was a very volatile situation. And I think that they're not going to be able to prevail here by saying that what was stated in The Sun was untrue. There was enough stated that was true. There's so much going on between this couple. The dirty laundry is just horrendous. So I think at the end of the day, the court is going to say, look, you know, they might not have gotten all the details correct, but there's enough information here to say that it's not libelous and it's not defamation.
You know, you have the reputation of The Sun on the line. You have the reputation of Johnny Depp. Then again, everything we've heard during the course of this trial, hasn't it tarnished his reputation? I'll get to that in a second. Before we do, let's go back to the recording because the issue of who is the aggressor and who is the victim, take a listen.
You don't even know what you're talking about. You still haven't even told me what it is, but run with it.
I have told you what it is.
No, you haven't.
I said to Travis, I said to you, hey, tell Travis what just happened.
You told me to do it. You told me to. You said, go do that.
I said, no, tell him what just happened.
And I lied.
And that you punched me in the
You're right.
fucking thing. And you
figured
in the
it
face.
out.
And you said, no, no, I didn't. What the fuck are you talking about? And I
didn't
watched
punch
you lie. And then
I didn't punch you,
and
by
then
the way. I'm sorry that I didn't hit you across the face in a proper slap, but I was hitting you. It was not punching you. Babe, you're not punched.
Don't tell me what it feels like to be punched.
You know, even a lot of fights been around a long time. I know. Yeah,
no, when you fucking have a closed fist.
You get punched. You got hit. I'm sorry I hit you like this, but I did not punch you. I did not fucking deck you. I fucking was hitting you.
You can't
I don't know
deck
what the motion of my actual hand was, but you're fine. I did not hurt you. I did not punch you. I was hitting you.
How are your toes?
What am I supposed to do? Do this?
How are your toes?
I'm not sitting here bitching about it, am I? You are.
Oh,
that's the difference between me and you. You're a fucking baby.
Because you start physical fights?
You're such a baby! Grow the fuck up,
Because you start physical fights?
I did start a physical fight.
Yeah, you did, so I had to get the fuck out of there.
Yes, you did. So you did the right thing, the big thing. You know what? You are admirable. Every single time. What's your excuse? When there's not a physical fight, then what's the excuse there? You're still being admirable, right? Just by running away. And you can sit here and call me names, but you get called a name, and what do? That's the last insult. You're a baby. You're a hypocrite. You don't do anything that you actually do. You expect from people what you can't give them.
Eklund, let me hit you with a two-parter here. Does it even matter if she hit him? The allegation here is that he hit her. He called him a wife beater. It's not a newspaper is not a court of law. And so let me ask you, does that matter? And two, the fact that his exes have came forward with statements to the court and said that he was never violent with them, those two factors, your thoughts?
Those matter. So here's the issue, is that you have, I see men in these types of position often, especially when you have the woman as the aggressor, you know, there's no way you got to block. You know, at one point, you're going to want this woman to stop hitting you. You don't want to call the cops. You don't want to have her arrested. You want to calm her down. Even in her statement, even while she didn't know she was being recorded, she stated, hey, I didn't hit you that bad. I mean, I know what a punch is. So she is already discounting her actions. So what you can see is that it's reactionary. So it's either and if I was, you know, Johnny Depp's attorney, I understand it. It's either you're going to put it out there that we're like Elizabeth Taylor and Richard Burton, but you cannot put it out there that I am the one, like I'm Ike and Tina, like I'm the one beating you. We were participating together. You have your faults and I have mine. And especially with this case with Mr. Depp, is that you can also see that she was so emboldened by the media coverage and she was so emboldened by everybody's support that she even made, a very emotional speech at one of the Me Too movements. I mean, one of the Me Too gatherings.
Right.
So it's that, like
It's a strange and difficult case and sad case and just a really disturbing case. At the end of the day, you have to wonder, did it do Depp more harm than good by filing this suit? Because, yeah, he wants to preserve his reputation, but look at everything that came out during the course of this trial. Is he ever going to star in a kid-friendly movie again? Maybe, maybe not. Now, again, if he were to win, he could win an unspecified amount of damages. And as we heard in this trial, he apparently lost $750 million in bad management. So there's a lot for him to gain. We will see what the judge ultimately decides in this really graphic case. I want to thank my guests. Appreciate it. Have a great night.